Namaskar viewers, I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the new criminal laws. In today's session, we will try to discuss some very significant topics related to the first information report. The concept of FIR, it has been broadened considerably to include concepts such as zero FIR and also e-FIR. So, in this session, we will try to understand what these two concepts are and what are the differences that have been brought about in the criminal justice system by introduction of these new concepts. So, first of all viewers, let us talk about what is First Information Report, FIR, or First Information Report as we commonly refer it to, or information that is first in point of time. The FIR must be in the nature of complaint, or it could be an accusation that is recorded by the police when they receive information about the commission of a cognizable offence. So, FIR is the first or earliest information that reaches the police regarding a particular crime, and that is the reason why it is called the First Information Report. The main objective of filing First Information Report is to set the criminal law in motion and also to enable the police officer to start the investigation of the crime committed and collect all possible pieces of evidences, interview witnesses and question the possible suspects, and at the same time take all required steps to apprehend the criminal before he gets an opportunity to tamper with evidences, influence witnesses, or before he gets the opportunity to simply escape from the area, so that the police can immediately swing into action and avoid any kind of tampering or any kind of running away of the accused person. So, what are the cases in which First Information Report is to be registered? Schedule 1 of the Bharatiya Nagarik Suraksha Sanhita 2023 enlists the offences that are classified as cognizable offences. For example, murder, robbery, etc. So, these are the crimes which require immediate police attention and preventive measures are needed to be taken by the authorities. These are offences which are generally more severe. These are graver in nature, and these are crimes which act against the public interest at large, and that is why these crimes have been categorized as cognizable offences. Now viewers, here I would like to make it very clear that just because there is an offence which appears to be very serious to us, does this mean that we can presume it to be a cognizable offence? The answer is no. What is a cognizable offence and what is a non-cognizable offence? It has been separately listed in the BNSS under Schedule 1, and we cannot apply our own notions to understand whether this crime should be made cognizable or not. It is something which the legislature has already worked upon, and we have a comprehensive list under Schedule 1. So, FIR is to be registered in cases of cognizable offences, and what are cognizable offences? We can refer to the list given under Schedule 1 of the BNSS. Now, the important question is, who can register an FIR? So, an FIR, it can be filed by any person who has either witnessed the crime or one who has knowledge of the commission of a cognizable offence. A police officer is under the obligation to register such an FIR for the cognizable offence. The person against whom an FIR is being filed can be the person who has committed the offence, one who has knowledge of commission of an offence and where he was supposed to inform the authorities, and despite knowing if the person has directly or indirectly contributed to the commission of the offence, one who has witnessed the offence, or one who has abetted in such an offence. See, abetment could be by instigation, by aid, by conspiracy, in any manner. When we talk about the informant in cases of FIR, so an informant doesn't necessarily need to have a first-hand information about the offence. Even an anonymous notice to the police that contains information about such an offence can be treated as a formal complaint. The police officer can also lodge an FIR himself if he has knowledge that a cognizable offence has been committed. So, for registration of FIR, the informant can be the victim, relative of the victim, some eyewitness, bystander, or largely anyone whosoever has information regarding that crime. Now, when we insist upon immediate registration of FIR, when we say that it is information first in point of time, this signifies that information has to be registered as early as possible. So, the question is there any effect of delay in registration of FIR? Undue delay, unreasonable delay in lodging the FIR does give rise to a suspicion that why was this delayed. Now, this puts the court on guard to look for a possible motive and explanation for the delay, and only then we can consider the impact of such a delay on the trustworthiness of the prosecution version, that why was this FIR not registered at the earliest. If there is a delay in lodging the FIR and the delay is unreasonable, it is unexplained, then it is likely to create scope for suspicion or introduction of a concocted story by the prosecution. So, it is the duty of the prosecution to explain the delay in lodging of the FIR. If the prosecution can satisfactorily explain the delay, if they have logical reasons why there was this delay, then the FIR does not lose its evidentiary value. However, it is equally important to understand that sometimes if there has been a delay in lodging of FIR, it would not necessarily be fatal to the prosecution case. There was a judgment in Raghbir Singh versus State of Haryana wherein the courts had held that going to the hospital due to condition of victim for saving the life of victim instead of going to the police station first was a reasonable and valid explanation for a delay in filing FIR. So, when you are faced with a situation wherein whether you have to first escort the victim to the hospital or whether first you need to rush to the police, and if you have taken the correct decision that you first rushed the victim to the hospital, so this is a sufficient and a justifiable explanation why there has been a delay in filing of the FIR. Similarly, when we talk about stigmatized crimes such as rape, such as sexual offences, what happens? This is a case which impacts not only the victim but the honour of the entire family of the victim. So, sometimes because of shame, because of honour, the family members, they do not contact the police immediately. Therefore, courts have consistently ruled that delay in registration of FIRs in cases of sexual assault, it cannot be equated with the cases that involve other offences. See, there was judgment of court in Harpal Singh versus State of Himachal Pradesh wherein the court held that delay of 10 days in lodging the FIR stands reasonably explained when the prosecution stated that the honour of the family was involved. The members needed time to describe whether the matter, to decide and then how it was to be described before the courts, because see, they were feeling a sense of shame. We have these warped notions of traditions and customs in our country, due to which a woman who is subjected to sexual offences is seen as someone who has lost her honour, So family members are also filled with a sense of shame that we could not safeguard our daughters, our women. So what happens, sometimes they take time to decide whether they want to move the criminal justice system or not. So they take time to decide whether they have to register an FIR or not, due to which sometimes the registration of FIR is delayed. But in such cases, it is a justifiable reason behind the delay in registration of FIR. Now coming to a very important point, and that is, where should the FIR be filed? So FIR is usually filed in the police station of the concerned area in whose jurisdiction the offence has occurred. Police is responsible for maintenance of law and order within their jurisdiction. They are expected to be well versed with the topography of the area assigned to them, and they also have resources to ascertain the likely hideouts of criminals and other miscreants who are operational within their area. Therefore, they have been entrusted with the exclusive responsibility of conducting investigations into crimes that are committed within their territory. If some other police officer also comes to apprehend a criminal from their territory, the other police officer is supposed to first inform the police of that area before making any arrests in their territory, because there is a possibility that the offender might have committed any offence in that territory and might be required by the police of that very jurisdiction also. So this is a necessary provision, because the criminal might be wanted in relation to crimes in more than one jurisdictions. See, jurisdiction is a formal issue which is for the police to decide. This is to facilitate investigations and at the same time to ensure speedy justice. Jurisdiction is not meant to act as an impediment. Generally, people are not aware of jurisdictional technicalities related to crime reporting. So what they do? They approach the nearest police station or one that is conveniently accessible to them. It is for police to ascertain the jurisdiction within which the crime has taken place. So now what the law says is, see, the victim, the informant might not be aware of the jurisdiction, but the police does, and now the police are supposed to put their information to good use. If people are to be turned away from police stations on grounds of jurisdiction, and if they are made to run from one place to another, it would be demotivating for good Samaritans who are unrelated to the crime in any way and were just willing to help or perform their duty of being a good citizen. For victims also, this would be extremely frustrating, as it would result in vital time being lost, thereby giving the accused opportunity to flee, remove evidences or influence witnesses. So now, in order to deal with this jurisdictional issues, the concept of zero FIR has been introduced in the statute. FIRs are recorded in a register specifically maintained for that purpose in every police station and then given a number. However, if the information is regarding some crime committed at a place which is not covered within the jurisdiction of that particular police station, then that information is recorded but not numbered. Thus, it is referred to as zero FIR. As per the standard operating procedures issued by BPRD, on the receipt of any information regarding the commission of cognizable offence which has been committed outside of the territorial jurisdiction of that police station, the SHO or the officer on duty records the details of the complaint in the zero FIR registered. Irrespective of the jurisdiction, they will register the case as zero FIR or O, which is the numerical 0, O FIR. So, you see, the FIR number is now prefixed with 0. Why? To indicate that it is a zero FIR. So, the copy of information as recorded under subsection 1 of section 173 of Bharatiya Nagarik Suraksha Sanhita shall be given forthwith free of cost to the informant or the victim. After the registration of zero FIR, if necessary, Primary investigation may be done by the investigating officer of same police station. For example, in cases of rape, immediately they might have to get the victim medically examined. After that, the next step is transfer. So, the officer forwards the 0 FIR to the police station having jurisdiction over the place of the incident. So, viewers, you see, although an ordinary person is not aware of the jurisdictional technicalities, but the police is aware of the same. So, now the responsibility is on the police officer to forward the 0 FIR to the concerned police station. Thereafter, the concerned police station receives the 0 FIR and re-registers it as a regular FIR in their records, and the SHO assigns the FIR to an investigating officer for further action. 0 FIRs, they also come in handy in cases of crimes that are committed during travel. The victims, they cannot be expected to go back to the same place where the crime took place. So, they should have the liberty to contact the police upon arrival at their destination, and then the police may do the needful. Now, after this concept of 0 FIR, let us talk about e-FIRs. The medium of filing a complaint has been made more flexible now. Earlier, an FIR could only be filed if an aggrieved person appeared physically at a police station and he submitted a verbal or a written complaint. Now, any complaint submitted via an electronic medium such as WhatsApp or email will also be accepted. So, now what does the complainant do? He fills in the required details or submits the requisite information in his complaint, including personal information, details of the incident and any supporting evidence or documents. The message that is so received in an electronic form, it may be downloaded by the police and it may be kept in a computer in the police station. The electronic information relating to commission of a cognizable offence may be entered in the e-complaint or e-FIR registered or as prescribed by the head of the department. The next step involves verification and preliminary inquiry. And now, this e-FIR, which was so submitted in an electronic form, is to be forwarded to the investigating officer for initial verification. If the information is sent through electronic communication, the same shall only be taken on record by police official after such an electronic communication was signed within 3 days by the person giving it, which means after signing the e-FIR, then a formal FIR will be registered. Now, there is a lot of controversy surrounding this because on one hand we are talking about digitalization, on one hand we are talking about electronic evidences and all, and on the other hand when we are insisting upon physical verification of the registration of the FIR. So, now what we have said, we have given the liberty to the informant to immediately inform the police, but then within a period of 3 days he has to physically visit the police station and then put his signatures in the physical form. Why can we not allow electronic or digital signatures to suffice in cases of e-FIRs? So, now this is something which requires a rethink on part of our authorities. Then, sometimes what happens, that information was sent through electronic communication to the police station, and that communication, it discloses a very serious offence. So, where the nature and gravity of the information sent to police station through electronic communication requires immediate action. When there is an immediate interference required by the police, then matter may be registered on behalf of the complainant by the IO himself after first initially verifying the facts and circumstances of the information. Then in such cases, the police officer will become the informant. In a way, it will be treated as if he had received that information and now he has filed the FIR. Because sometimes if you receive information of an accident, you receive information that some person is grievously injured, so you might have to act immediately so as to do something to save the life of the person within the golden hour. So you cannot wait for a period of 3 days for the informant to first visit the police station, put his physical signatures before you take any kind of an action on that. So, the introduction of e-FIR, or what we know as the electronic FIR, is with an objective to leverage technology to simplify the process of reporting crimes, making it more accessible to the public, reducing the time that is required for registration and subsequent action. So, this is a system that is designed to eliminate geographical constraints and bureaucratic delays so that we can ensure that victims of crimes can report incidents promptly and accurately regardless of their location. See, sometimes there might be geographical constraint due to which people cannot visit the police station immediately in physically. So, in such cases, registration of e-FIR is a very good step in this direction. Similarly, suppose there is a person who is trapped within a house and the person needs to escape. Suppose there is a person who has been locked by someone else. Now that person somehow manages to get a mobile and inform the police. So, you cannot expect the one who has been locked to break open that lock and go into the police station and put their signatures, only after which the police will take any action. In such cases, it is a system that has been designed to eliminate all these kind of delays so that victims of crimes can report incidents in a prompt manner, in an accurate manner, and police can immediately swing it to action. Similarly, when we talk about another good concept, that is zero FIR, which was earlier also there, we had certain reports that mentioned that, we had certain decisions talking about zero FIR, but it is only now in BNSS that zero FIR has expressly been mentioned when it says irrespective of jurisdiction. So, that implies that we have done away with jurisdictional hurdles. So, what zero FIR does? It addresses the critical issue of jurisdictional limitations, which have historically, since old times, they have impeded the swift initiation of criminal investigations. Now, by allowing any police station to register an FIR irrespective of the place of occurrence, zero FIR ensures that no time is lost in starting the investigative process. Thereby, we can immediately provide relief wherever it is required, and at the same time we can ensure a quicker response from all the concerned authorities. Now, when we talk about registration of FIR, many times there is a query as to is there some provision in the law regarding cancellation of FIR? So, viewers, there is no provision in the law for as it is cancellation of FIR. It is open to the magistrate to agree with the police report or not to agree with the same. FIR can be cancelled by the police officer or investigating officer at the first instance after finding during the investigations that there is lack of evidence or case is not proved. And then what can be done? A closure report can be filed, and that is something which you can refer to as cancellation of FIR, but expressly there is no provision for cancellation of FIR. It is only when you do not have sufficient evidence to proceed with the case that you can file a closure report. Now, sometimes a person goes to the police station, but the police officer refuses to register an FIR. So, what can be done in such cases? So, as per section 173 subsection 4 of the Bharatiya Nagarik Suraksha Sanhita, any person who is aggrieved by a refusal on part of an officer in charge of a police station to record the information referred to in subsection 1, then such a person may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself, or he shall direct an investigation to be made by any police officer who is subordinate to him in the manner provided by this Sanhita, and then such officer shall have all the powers of an officer in charge of the police station in relation to that offence, failing which the aggrieved person may make an application to the magistrate. Under section 199 of the Bharatiya Nyaya Sanhita, whoever being a public servant fails to record any information given to him under subsection 1 of section 174 of the BNSS in relation to cognizable offences that are punishable under section 64, 65, 66, 67, 68, 71, 73, 77, 124 or 143 or 144. So, we are referring here to sexual offences, rapes, acid attacks. Then in such cases, there is no discretion whatsoever with the police officer. He is bound to register an FIR, and if he refuses to do so, then he shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years and shall also be liable to fine. So, students, before we conclude, I would just like to say that incorporation of zero FIR and e-FIR in India's new criminal law signifies a transformative step towards modernizing the country's criminal justice system. Zero FIR allows victims to file FIRs at any police station irrespective of jurisdiction, which ensures easy access to legal recourse. This change is particularly beneficial for victims in urgent or threatening situations, which facilitates immediate police action and aids in the timely preservation of evidence. Along with this, the introduction of e-FIR enables the online filing of FIRs, making it more convenient and accessible to all. By leveraging technology, we can reduce delays and administrative burdens. Together, these reforms enhance the efficiency, responsiveness and inclusivity of the legal process, reflecting a commitment towards victim-centric justice and aligning with global best practices. However, their success will depend on adequate training for law enforcement, public awareness and a robust mechanism to ensure accountability and at the same time to prevent misuse or abuse. So, students, that will be all for this session. I hope you did find it informative. Thank you.